Welcome to the Futurist Public Intellectual. On April 19th, 2024, the Department of Education issued the final changes to Title IX of the Education Amendments of 1972. It repeals some of the changes that the Trump administration made in 2020, and in particular, it adds protections for BGLQT students by adding language about sexual orientation and gender identity. These rules were supposed to go into effect on August 1st, 2024, but because 10 states sued to block the 3 provisions that specifically relate to gender identity, the rules have been in limbo. The Supreme Court decided last week to not allow the Biden administration to enforce any of these changes, even though only 3 provisions are being litigated. While all of the justices agree that the states are entitled to a preliminary injunction to block the rules while they're being litigated, the Biden administration wants the rest of the uncontested rules to be enforced. 5 of the justices concluded that the Biden administration had not sufficiently proven the severability of the uncontested rules, so they're going to allow the preliminary injunction to block all the rule changes. Justice Gorsuch and the 3 liberal justices disagreed, saying that the injunction should only be as broad as necessary. This development with Biden's rewrite of Title IX is interesting because it comes less than 2 months after the Loper Bright v. Raimondo case. The Loper Bright case overrules the agency deference rule that was promulgated in Chevron v. Natural Resources Defense Council, complicating this Title IX situation further. In other words, the courts now don't have to give deference to an agency's interpretation of an ambiguous statute. Prior to Loper Bright, I would say that the dissent's position is very persuasive. As a general rule, preliminary injunctions aren't supposed to be overly broad. However, these rules are agency rules, i.e., the rules of the Department of Education. So it's legally reasonable to think that all of these rules might be imperiled by Loper Bright. If these rules turn out to be inconsistent with the Education Amendments of 1972, then the federal courts will strike down these rules anyway. However, due to Bostock v. Clayton County, the Supreme Court might decide that the agency correctly interpreted the statute too. In light of the confusing situation, the majority and the dissent are both correct. Thank you for listening to the Futurist Public Intellectual.